Here's the questions you may get all the time, as realtors or homeowners may have them. Can the lender come after my assets or my future income? Should I stop paying? Can I protect my credit? Will I owe the IRS or California tax money, and why? Should I do a loan mod? Can I reduce my principal? Should I take a foreclosure? Should I consider a short sale? What is a deed in lieu? These are just the beginning, and these are the questions that need to be answered before a client can feel confident that they're embarking on, if you're a realtor, on a short sale, and the short sale is the right thing to do, and that they'll have the patience to provide their finances 2 or 3 times to the bank. It really helps to have a client well educated, and from a homeowner, there's nothing like knowing what's going to happen as opposed to wondering. We're going to quickly now address what we did. What we do was an underwater analysis, and what your realtor or you can do for yourself. Hello, John McConnin again. You may notice at the end of my 5-minute segments, I start rushing. My recording software does 5 segments at a time right now. Here is, in our presentation, I was explaining that we do an underwater analysis. We look at a person's options and the effect that those options will have on their exposure to the deficiency, exposure to tax liability, both federal and state, and the credit consequences of what they do, and what they might do to have their credit effect minimized, or to be able to clean it up fairly quickly after the loan workout has been completed. Now, it's not just the law which makes a difference. It's also knowing the lenders, knowing what they're looking for, knowing the probabilities of the expected workout scenarios based on your income and your assets. So it takes some experience. We put on webinars and seminars, and we are going to make these even more prevalent if you join. But you want to work with someone in the group that you're working with needs to have experience, because otherwise you can't really take educated guesses and make dynamic adjustments as the process goes on. So let's start with the first thing, granddaddy, I don't need to use that. Perhaps the most important right, anti-deficiency right in California. It's California Code of Civil Procedure, CCP 580B. No deficiency judgment shall lie in any event after the sale of real property or an estate for years therein for failure of the purchaser to complete his or her contract of sale, or under a deed of trust or mortgage given to the vendor to secure payment of the balance of the purchase price of that real property or estate for years therein, or under a deed of trust or mortgage on a dwelling for not more than 4 families given to the lender to secure repayment of a loan which was in fact used to pay all or part of the purchase price of that dwelling, occupied entirely or in part by the purchaser. Now, as you can guess, and it's really that last line that's quite important. There's been a lot of case law that springs up around this. There are myriad questions about whether, like, for one, when could a refinance still be considered a purchase money loan or a non-recourse loan? And the answer is that there is some case law that says if you've refinanced with the same bank and you didn't change the principal, then it might still be a non-recourse loan. I think the theory behind that is that it's really very similar to it being a loan modification. Now, again, you may know that, but the bank's going to pretend they don't know it. So it's really a game of you using your legal leverage against the bank and having an idea of who will win. But again, if the bank were to sue you, it's going to cost everybody money to have a court declare that your refi was a non-recourse loan. So we would counsel a client to say, well, you probably have a non-recourse loan, but in your case, it might make sense to try to get some other type of loan workout done rather than bet it all on a foreclosure. So those people with refinanced loans with the same bank are probably excellent short sale candidates unless they have tons of assets and tons of money. And we'll go over that, the reasoning for that at other times. So anyway, if you've got the original loans on your residence, now what does residence mean? Is it your principal residence? Well, yes. Is it a secondary residence? Some lawyers argue it would be a secondary residence. So again, that's why we have an Ask a Lawyer place for our clients. We're going to have an underwater every Wednesday. People can post questions, and I will do my best to answer them all inside our community at underwaterrealestate.us. We answer realtor questions all the time, and we will also put on webinars on these subjects. There's just myriad questions. But one thing is that I like to look at it as this. If you've got the original loans on your principal residence in California and you take a foreclosure, that will turn out to be a non-recourse loan. If it's a non-recourse loan, you won't be responsible for taxes to the state or the feds. You won't be responsible for the deficiency to the bank. And we'll go into credit repair at a later stage. Our next set of anti-deficiency rules, we're going to group this one together with CCP 726 as well. If you read this, you'll see that upon the sale of the mortgage under power of trust, so that's a foreclosure sale, a private sale. This is a non-judicial sale, but this is how 99% of the foreclosures happen in California. That upon that private sale, no judgment shall be rendered for any deficiency upon a note or deed of trust or mortgage. Now, when you combine this with 726, which says there can be one form of action for the recovery of any debt, and you combine the one action rule with what the courts have implied in, the flip side of this rule is also the security first rule. The courts state that if there is a lien they can execute against, or the mortgage they can execute against, and basically if they can take back the property, or they could go after a client for the loan, if there's security there that they have to take back, the courts have said, due to the one action rule, they have to take the property and first. So when they take the property, that's their one form of action, so they can't pursue the remaining loan balance. So this obviously for people with non-recourse loans, financially it's not going to make a difference. But for people with one recourse loan, the bank in California is supposed to take the property back first. Then it's their one form of action. 580D says no deficiency. Now, what happens when there's two loans? Well, if you're not paying both lenders, if the homeowner's not paying both lenders, and the first forecloses, then there's no more property to take back. So therefore, since they don't have any property, since the second won't have a property to take back, they could go against the homeowner directly for the contract. They could if it's a recourse loan. If it's a non-recourse loan, then they can't. So if you've got a recourse second, there are times when you want to make sure that the first can't foreclose, whether that time be during a short sale if you're getting close to the foreclosure date, or if your goal is to do a foreclosure, you have to look at certainly a two-step foreclosure, and you might consider a two-step short sale if you have a large second. We will get into the two-step short sale and other concepts, how to use these laws to leverage your short sale negotiations or your foreclosure negotiations in greater detail in webinars and in other and inside the community in our client education pages. But just know that if you use these rules and you time things properly, you can really put the short sale servicer in a difficult position vis-a-vis their investors, and they frequently don't want to. And that's when previously we're trying to be nice. We advise to have a great person in your office who's competent, who has a file in control and can speak nicely on the phone. And when that doesn't work, that's when the legal letters go out asking the servicer if they've advised their investors that whatever it is, it could be the one action rule is going to get them, or the non-recourse. Frequently, the CCP 580B is something that they haven't considered. So there's times for it's that honey things. I guess you get more flies with honey or whatever. The banks appreciate it. The workers appreciate it when you treat them with respect. But sometimes you've got to get to their investor. Now this is where I just went over the security first rule. But so far we've got 3 anti-deficiency laws we're looking at. Here's the 4th. In some case law, and it's evolving and not evolving for the better, But when I got out of law school, we used this a lot when we were counseling clients about their options. Because I worked, one of the partners did a lot of bankruptcy work at the firm, and this is what we discussed. If they were only upside down, they didn't really need to, they might want to consider just working something out with the bank. Because, and this law was used a lot back then. If you have first and the second are owned by the same company, when the first forecloses, and I should say entity, that if the entity forecloses on the senior, then their interests in the second get merged into the first. So if you've got the same entity foreclosing, then when they foreclose on one, it's like foreclosing on all three or two, or whatever the case may be. The issue these days is what is an entity and what if they sell it off? And that's where the Ninth Circuit case got confused on the sell-off situation. So with this merger of interest idea, especially with even like the banks got smart, and they'll be B of A home versus B of A home equity, or B of A home, they have different names even at Chase, and B of A and Citi, and it's usually the difference between a first and a second, and sometimes a first, second, or a home equity line of credit. And we also know that Chase told Congress, like when you call Chase, they always say they own the loan, but they told Congress they service 70% of their portfolio was servicing. So I saw the executive officer for Chase, or if not the president, vice president, state that to Congress. So it always kills me when every single loan I have with Chase is owned by them. It's pretty funny. Nevertheless, we do know Chase does sometimes own them because those are the short sales that go really fast. But that's a side point. Now, they have investors. The investor groups, when they're frequently fronted by Fannie Mae or Freddie Mac or Fannie Mae, we don't really know how this is going to get washed out factually or in the courts. So the merger of interest argument I like to keep as leverage, and I advise my clients not to rely on it. But if they can't stop a foreclosure and they've got a B of A first and a B of A second, I suppose if the collection people come, and it was a recourse second, when the collection folks come after them, this is the line of defense. One of the lines of defense we put up. We do a disputed debt, asking for voluminous but important and integral questions, which they won't respond, and maybe you can set up the file well for a good argument in the future. Hopefully, it doesn't get there. But again, it's nice to know it's like a waterfall defense where you are, and then sometimes that defense can turn into negotiation leverage. I think we are going to cover. Are we done with the anti-deficiencies? Oh no, good. I did include 580E. Now this one's huge and it's constantly evolving. And I'm not even sure whether I wrote this before. Oh no, it's after July 15th, so it's up to date. Now the beauty of 580E, it says, is that if the banks agree to a short sale in California now, two things. One, they agree to release the remaining loan balance, and two, they're not allowed to ask, they're not supposed to ask, or they're not supposed to get a contribution from the owner. This brings up, and then three, I'm going to talk about the practical effects of this. One, I get questions all the time about what happens if the law changes. And retroactively, would the case law go back and erase this? Would the legislature go back and erase this? And how would the courts deal with it? I consider that a minor risk. I'm sure some lawyers would put it close to zero. It seems minor. I think that at least while this law has not been repealed or eviscerated by the courts, I think that it's reasonable to rely on it, although it doesn't hurt to have bootstraps and a suspender and a short sale and get the bank to erase the language that's contrary to the statute, because we still see a lot of it. Secondly, with respect to contributions, we're seeing some major banks, as we speak, Wells Fargo, on a couple of my short sales, has asked for some contribution from the seller. Well, the seller, is it against the law for the seller to contribute? That's a good question. Should the seller contribute $3,000 if they have it, rather than $120 hanging over their head, or maybe getting the short sale all maybe even canceled? So all these questions, I think that you need to deal with on a case-by-case basis with clients. You have to know this next point too. Many of the seconds at the medium-sized banks are no longer accepting the $3,000 to $6,000 the first might pitch them in a short sale negotiation. You're going to have to find a way to get larger numbers to the second, and that might be by representing both sides and pitching in your buyer commission. I know realtors don't want to hear that, but that may be the one. That's occasionally the only way to get it done. If the first is not allowing a contribution and your client doesn't have time to reinstate the first, work out a negotiation with the second, and then come back to the short sale, which is why it's very important to set this up ahead of time. If you've got a big second, for many people with recourse loans, it's wise to go in, negotiate with the second, and then go and negotiate with the first. So if there's big seconds, I believe a lawyer should come in and go over all the options with the homeowner. Okay, Mortgage Debt Forgiveness Act. We had a detailed video that you may have already seen prior to this one going into that. Let me just say that as of now, it expires in 2012. I'm speaking in February 2012. If you've got a recourse loan, you really need to, and a second, you really need to have a backup plan at this stage, because a short sale or a foreclosure might not happen in 2012. So especially if you've taken cash out, you might want to consider all your options. For people with recourse seconds, one way around the issue that we discussed with people before the Mortgage Debt Forgiveness Act came about was setting up the property as a rental. So especially if you haven't taken cash out, if you set it up as a rental, then you should talk to your tax advisor, but there's a chance that you'll be able to offset that 1099, which could be six figures for a lot of my clients. You could offset the 1099 with the loss that you have on the investment if you actively managed it. So that is one idea that works for a lot of homeowners. If you have a non-recourse loan, then it wouldn't matter. The other thing that you seriously need to consider, and I know this is aggressive, and non-lawyers are on the net warning about it. I've seen a couple of lawyers, but I can just say that it's worked in my life. And that is when you dispute the debt legitimately. I had a very legitimate dispute. The student loan company had the student loan under someone else's, not my name, and someone else's social security number. And then they came back after I had paid off all my other student loans. And at the time, there's a lot of money, like $50,000 or $60,000 worth in the early 90s, mid 90s. And 2 years later, out of the blue comes the $2,500. I argued with them for years. I eventually made some money. I bought a used car actually off my roommate, but I was thinking about buying a new one. I went in, I found they were still messing with my credit. I called them up, threatened to sue them. It was disputed. They eventually took a very, very small amount of money. And then later, I found out like a year and a half or 2 years later, they said send in a 1099 saying I owed, for $2,500. And I told the IRS that this was a disputed debt. And this was even before the case law. There's case law now called Zarin. I think it's probably Zarin versus a commissioner or something else, like all those tax cases. But Zarin sort of showed that at least in certain circumstances, a legitimate dispute of debt does not result in the need to pay taxes on the 1099. So with that as the background, how would you go about setting this loan up as a disputed debt? And this is why I say it's important to be part of a community and following what's going on in the press. I just heard on the news this morning, and I hardly ever listen to AM radio, but I did, that I don't even know what state, but one of the attorneys generals in a state found that just some unbelievable amount on 400 loans. I think they found there was, in my mind, I put it at over 90%. 90% of the mortgages had at least one, and most had more than one violation on them. And we know that California's already done settlements with B of A. We know that the robo-signing settlement was just announced a few weeks ago. If I were going to experience a big 1099, I would have a lawyer help me dispute the debt and request the documents, pointing out the issues with robo-signing and maybe overpriced houses and inflated appraisals and myriad other issues. I would set that up with a letter I would set that up with a letter disputing the debt behind it, maybe a qualified written request under RESPA. I would document the file. Now, you can either be super persistent. This goes beyond my law practice. Usually, I mean, you could pay by the hour, but not in our short sales. But if you want to follow up and be super persistent, you might get the documents. We occasionally did in the past when we were doing this by the hour. Or most likely you'll get the banks responding with a form letter and not giving you any of the information. Then I would consider following up with that. There's certain things you probably want to consider. But at some point, I'd establish a file and show that there was a legitimate dispute about whether these loans are collectible, whether they were violations of law in the first place. And I really want to emphasize that collectible aspect, I think, is consistent with the Zarin case. We'll, in our forums, we'll have the Zarin case and some of the language up there and compare and contrast. But this could be a great way for people with recourse loans to legitimately dispute the debt and therefore not be afraid of a loan workout now, or at least not be afraid of the tax consequences. Credit issues. We always have them. And we can go over our experience, what works, what doesn't, what happens for most people. myfico.com, since that's the company that does a lot of the scoring, you probably want to go there. Know that they give the, in my opinion, the bottom line, sort of like the worst situation, because you can do better than what MyFICO says. I mean, for instance, we have clients. Oh, I'm trying to change that I right now. Liability issues. We have some clients who don't see their credit get hurt at all because they're keeping all their other credit lines open. I mean, it only goes down 50 points. We see others whose credit collapses, and we're starting to see patterns and reasons and why. Now, you should know there's a difference between your credit history and your credit score, and you should also realize that if, as we just discussed in the previous slide, if the banks have trouble showing that they have a right to service your loans, and believe me, they do. That's documented in our files. If they have trouble proving that in California law, the courts might not love this argument as much, but I think it's legit. If they can't even show you where the original note is, and there's not supposed to be a severing between the note and the deed of trust, if they can't make the original available for copying, they may have trouble having a right to collect on the note. And I'm not saying sue them and keep the house. That clearly doesn't seem to be working in California. But does this create serious credit issues for the bank? Yes. Are there ways to use these issues set up properly, with your lawyer on legal letterhead, or set up logically using the Fair Debt Collection Practices Acts? Yes. Would it take a lot of work to clear up your credit? Yes, it does. But could that result in you being able to buy a house sooner? Yeah. We have seen, we don't really practice credit repair full time, but we've done it for some people. And we've recently seen some credit getting repaired when you have, they've got 30 days to respond. You challenge them. They can't produce. They can't explain. Then you have to go and tell the credit repairing agencies to remove it. But it can work. It's a lot of work. But if it's important to you, we're going to make that information available for you and for the realtors so they can advise their clients on what they know within the extent of what they believe they're allowed to talk about these things. So this brings us back to short sale versus walkaway. Recourse loans, non-recourse loan, non-recourse first versus non-recourse second, non-recourse first, recourse second. Let me go over this. If you've got a recourse senior loan, you know that 99% of the time that banks are going to foreclose in a non-judicial manner. Therefore, the one action rule will help you. Are there times when you might not want to rely on having a non-judicial foreclosure? Yes, there are. For practical reasons, we know I've had two clients who have been sued judicially. Both of them had title issues. I had one other client sued non-judicially. He had a second. The bank admitted they made a mistake. Now, if you don't have title issues, are you likely to see a non-judicial foreclosure? Absolutely. But I know from having clients in Rancho Santa Fe and some luxury short sales and luxury high-end clients that banks, when you've got $1 million or $2 million, $3 million mortgage, you're not dealing with the normal $15 an hour employees at the banks. Those employees are generally smarter, more experienced, and I think that you want to be careful before you give them a roadmap to your assets. If you were to tick them off, or they got smart all of a sudden, said, hey, we can collect from this guy in a judicial proceeding, they'd have to probably keep the property a year, which is a problem for them based on your right of redemption in California. But, it's a risk. So, recourse loans, if you've got a lot of assets to protect, you might not want to rely on a non-judicial foreclosure, although the practical aspect is it's almost always going to be non-judicial. If you've got, I think we covered, I stopped, it's been about 10 minutes since I started recording again. I think we stopped off on the recourse loan. On a non-recourse loan, again, these are the best loans to have. They definitely put you in a driver's seat in negotiations. You can show your assets and not fear that they're going to be able to come after you after a foreclosure, even if they go judicial. So non-recourse loans are a nice thing to have. The banks pretend they don't matter, but they all recognize what a non-recourse loan is in California. Realtors and lawyers have been educating them now for years, and they tend to have better results for short sales when people have assets. Not all the time, and we get almost all our short sales closed. But you have to set them up right. You got to pay more attention to them when they're recourse loans. Recourse first versus non-recourse second. The issue there is if you have a lot of assets and a lot of income, do you want to expose it to the bank? I certainly think that you might want to consider having a lawyer negotiate your file in those circumstances, because there's certain things we're not going to show. Now, we don't lie when we don't show it. We explain why. We say there's privacy interests here, comes from a law firm. Really oddly, the banks respect that well more than 50, 60, 70%. I'd say more than 70% of the time when you make the stand in the right place. So that makes doing the short sale easier with the first. You might want to consider a two-step short sale. So you deal with the second first, then you go to the first, and if you don't like the deal the first cutting, or they threaten a judicial foreclosure, you have saved up the money, you haven't paid them, and you reinstate. So there's a bunch of strategies that would go on. Now, a non-recourse first, again, it's like looking at a non-recourse. It's generally like looking at a non-recourse loan when there's only one loan. Recourse second, that's the tricky one. The recourse second, with 580E, if it's a big one, you seriously have to be prepared to reinstate the first, or maybe never go late on the first. Use that as leverage against the second, and then see what they say in the short sale. And if you're still paying the first, and you can get to a short sale scenario where you find out they want $20,000, well, then it's going to be up to the first. Sometimes the first won't let you put money on the HUD, more money on the HUD to the second. Title. You got to make sure you're working with a title company that's going to be on board, because we've seen them try to prevent. I've gotten calls from other people. We work with the same 2 or 3 title people all the time. But that's why you got to work with intelligent escrow, very experienced escrow, and title. Title loves to block deals at the last moment. It's just weird. And that's why you've got to sometimes have the lawyer say, well, I'm going to talk to your title attorney, and I'm going to put it on record, and if you prevent this deal from closing, you will be responsible for the deficiency. I found that one works quite well. Of course, it makes the title people cry, and you might not want to work with them anymore, but your deal gets done. And basically, it's just better to work with title that's on board with the way you operate than have to deal with the buyer's choice of title and the nightmare of inexperienced title or escrow comes into play. But we talk about all that in our strategy sections. When you're members of the course, we go into all of this in more detail. So basically, our job, and if your clients join our site through you, they're going to get this background information. You're going to get the background information. You can present it to them. You can say, for more information, go here. We'll have webinars. There's going to be Ask an Attorney. We're going to answer as many emails as we can. Right now, making a commitment to answer all of them. But, eventually it's going to be very repetitive. We'll have to break it down into chunks. But at least while you join now, we're going to answer all your clients' questions. We're going to answer all your questions that you can put up in our members section. And then this we already sort of covered. I'd like to have the release in writing that releases the deficiency, but it's probably not necessary. And then we have, we're just about done with this video soon. These are questions to ask to set the strategy. And I'm going to go see how many more slides we have. This may be our last video. So John McConnin, underwaterrealestate.com. Take a look at these questions that we go over before we help people set a strategy. We may come back and have one more video for this series. Thanks, John McConnin. Certainly, if you'd like to know more, be part of our community, you can fill out the information on the side. Thank you.